Let us start with the lawsuits, shall we? And the first one up, per popular demand, is our girl, Denims. So we've got this one. Obviously, this is filed 80 pages. Strap in, boys. Once again, we're going up to 2.5 hours here. This is in the United States District Court, Central District of California. So 2 things to note: California, but this is in U.S. courts, I mean federal court, not state court. So there's the federal rules of procedure, not the state rules, right? And this is in the Central District of California. This is TED Entertainment, California Corporation, versus Alexandra Marwa Saber, a.k.a. Denims or PKA Denims. And you can see here, jury trial demanded. So I would presume that if this proceeds to trial, there will be a jury trial. So typically they will grant that. So let's go down here. You've got this one, and here you got The Nightmare on Denim Street. So I've talked about legal writing. Legal writing is boring, and judges are humans. You want to entertain them. So while many people may find these things silly, as long as they are not distracting, adding something interesting that is not completely distracting is okay. It's fine in legal writing to be engaging. You don't have to be boring. That's a misnomer about legal writing, that you have to be boring. In fact, the best legal writing tells a story. Humans like stories. Everybody likes stories. I love stories. I read books all the time, audiobooks, everything else. I love stories, right? I read the 40K novels all the time. You've got to keep people engaged. And legal stuff is no different. If you can make it interesting and keep people laughing or, just engaged, paying attention, that's good. That's really good. Back to The Nightmare on Denim Street. Okay. Back to The Nightmare on Denim Street. All right. We're relying on you to stay live. So we don't have to give the Nuke views. Yeah, I'm going to stream it since he's confirmed it's coming out today. I'm going to stream it, Denims, prior to reacting to content Nuke is on Piker. So you start strong. He started with an engaging title, Nightmare on Denim Street, and a engaging quote, which goes right to the heart of it and really is the most damning piece of evidence. So he's putting at the beginning of the complaint, at the beginning, up front, the most damning evidence against Denims. That's the way to do it. That's correct. You start with something really strong that you're like, that the judge can't disagree with. It's like in sales. You start getting people to say yes. That's sales psychology. And it works in general psychology. If you start by asking someone to do something small, like, hey, can I borrow a pen? Or, hey, can you get me a glass of water? You continually ask them to do other things and agree with you until they're agreeing with you on things that are more extreme. That's basic psychology. So it works in writing as well. And this is what they're doing here, which is smart, which is clever, which is good. And yeah, it's effective. Well, guys, if you enjoyed not giving any views to that terrible video, give me a follow, subscribe, and throw a prime if you like my content. So this is once again going to the heart of it. It's strong evidence that is saying directly, we are siphoning views. We are using ourselves as a substitute by not giving any views to that video. Big oof. These two are the best pieces of evidence that he has. And then we're going to go from there. Okay. This lawsuit is about ending the practice of lazy reaction videos that copy entire copyrighted works and purposefully siphon revenue away from the original. Let's start with this first sentence. It's really important to break it down. If this first sentence was just this, I would have a problem with it more than and this, right? This is ambiguous. Lazy reaction videos that copy entire copyrighted works. That is something that could be legal or could be illegal. It could be okay to have a reaction video that someone else calls lazy but is actually legally sufficient. So lazy is subjective. It's a wide open standard. So what is a lazy video? Some people have called like reacting, like putting on a documentary and like reacting to it, talking to it, and putting on points and say, oh, that's kind of lazy. What's lazy is subjective. So I don't like that. But they added the other part to it. They added purposefully siphon views and revenue away from the original. So when the judges are looking at this, they're saying, oh, we're not ruling on just whether you can react, because that's kind of gray area. It's react plus. Do that. And remember, he's even made it better for reaction streamers. So reaction streamers, he said entire copyrighted works. So in this case, the judges could rule in favor of Ethan, and you could still view a part of the video and it would be okay, as long as you don't review the entire video. So the precedent could be limited to only people that watch all of the content and explicitly siphon views. So there's two ways to limit that down, to make that more narrow. And I think those are reasonable ways, and I think they're legally enforceable, and I think those would be an objective standard. It has to be the entire video, and it has to be purposefully siphoning views. Those are very objective standards. Entire video, purposely siphon views. I can agree with that. I don't have a problem with that legal standard. All right, back to the lawsuit, so we're not here all night. Over 7 years ago, the owners of plaintiff Ted Entertainment, Ethan, and Gila Klein established the legal standard for fair use in Hosadiah versus Klein. So this is very fun fact about the Kleins. They have been involved in copyright lawsuits. So what this means is they have lawyers that are experienced here. So while the Kleins have a major advantage, both in money and experienced lawyers, now Denims, Frogan, and Caseytron, they might be out there getting the Saul Goodmans of the copyright law world. We have no idea. They may have to get the strip mall lawyer, because frankly, I don't think they're going to have enough money for the white glove, top tier New York law firms or California law firms that are at the top tier of their game. I just don't think so. I think they're going to end up with some guys who may have a mismatched blazer and pants in the courtroom. Who knows? But when you cite your own cases, this is going to be interesting. As a genre, reaction videos vary widely in terms of purpose, structure, and extent to which they potentially rely on copyrighted material. Reaction videos like the Klein video that intersperse short segments of another's work with criticism and commentary constitute fair use. I agree with this. Short segments are okay. In contrast, reaction videos are more akin to a group viewing session, and they do not. I generally would agree. However, I think some videos which add value are transformative. So if you are commenting on a 30-minute video and you add 30 minutes of commentary, I think that is clearly sufficient in my mind. Or an hour of commentary. Typically for me, whenever I review a video or review a clip, I tend to add 2 times to 3 times more commentary, I've counted, than the length of the video. So if I'm reacting to a 30-minute video, it's going to be at least 30 minutes, maybe an hour of commentary if I'm going through the whole thing, which is why I don't like to do that very often, because it really lags. It really goes long. This involves the group viewing session hosted by defendant Alexandra Marwood-Saber, aka Denims. Denims specifically identified her group viewing session to siphon views and revenue away from the copyrighted work. The Content Nuke and the H3H3 Show 105 Countdown to Doomsday, collectively the work. So, by the way, he's suing for 2 videos. So that's very important fact here. Denims timed her group viewing sessions to coincide with the exact moment that he released the works. This is also deadly. This one is also deadly. The fact that she did it live. She didn't even wait. She did it live. If she had waited and done it the next day or done it 2 days after, Denims would have a better argument. But she didn't wait, because these people are impatient idiots. They have no idea about the law. They have no idea about anything. And doing things like that, doing things live, and was perfect. It really put her in the worst possible legal position. She's screwed. And once again, never 100%, but we're approaching, I think, upper 70s, 80s, 90s in the percentage chance. I would even say right now, before I read any more of this, at this point, I'm leaning on the 90s% for side of Ethan, legally speaking, not personally speaking, legally. Her timing was intended to capitalize on the intense public interest in the works and siphon the maximum amount of views and revenue away from the works to herself by showing the works in their entirety, or nearly their entirety. The moderators of the H3 Snark subreddit, the H3 Snark mods, heavily promoted Denims. Now, these guys should be, as you would say in French, shitting their pants. These people should be very, very concerned, because I think these mods were speaking very freely in their DMs and their messages, etc., other places, and all of that is subject to discovery. And all these DMs and messages and emails between these moderators being subject to discovery, which means Ethan Klein is going to get them, and ultimately we the people, we the public, are probably going to get to see some of those. That is going to be gold to see the conversations that they had and the intent behind them. Because these people weren't careful in their emails and DMs. These people were malicious. These people were, I guarantee you, I don't need to see them to know this. I guarantee you they were, which is going to be killer. And I think this is going to change the culture of a lot of these subreddits and other communities that now realize, hey, we're fully open and exposed here, both legally and in terms of what we did. It's not private. People think these messages and things are private, and they're not. As a direct result, Denims viewing sessions peaked at approximately 45,000 concurrent views. Holy smokes. While the previous stream accomplished only 33,000. Well, we're beating Denims right now, but 45,000 concurrent viewers. I mean, we got almost 9,000, 8,500, 8,600 now, but damn, that's a lot. Denims greatly profited from her group viewing sessions of the works through advertising, revenue, donations. So what this is clear damages. So what they've established is the damages are not ambiguous. And this is required for all claims, particularly for copyright. The damages cannot be ambiguous. They have to be specifiable. They have to be able to know what amount of money was lost. And you can look, because we have analytics for every video. For all my videos, I can go to the analytics tab and I can see exactly how much revenue that brought in. Same thing for Denims video. We can find out exactly how much money that has. So all of that can be taken away with a Thanos-like snap by the court. Like most lazy reaction videos, Denims peppers her group viewing sessions with brief and sporadic observations, which can be characterized as follows. Most frequently, Denims will watch long, unadulterated portions of the works and briefly pause to give a short surface level and repetitive observation that provides little to no new information, new aesthetics, or new insights on the works. So here's what he's doing right. He's using a citation from a case. So he's not inventing new case law. He's saying, literally, look at this case about the Andy Warhol Foundation versus Goldsmith, which is a very famous case. And this is a standard. If you provide no new information, new aesthetics, new insights, or new understanding, that is not transformative. Other times, Denims commentary has little, no critical bearing on style or substance. Same case. Rather, she goes off on tangents regarding unrelated subjects or shadow boxes. I like this word. This is a good one. Once again, good language. Shadow boxes, demonstrably false representations on the content. Okay. A rare occasion. Now, once again, shadow boxing could be criticism. So this is something I will give a little bone here. So making what's called a straw man. So a straw man is making like the weakest version of someone's argument. That's actually okay. You can straw man people's arguments. You can also steel man them, which is making the best possible case. I usually try to steel man the other side. I try to give them the best possible option. In this case, I am actually giving them the real steel man. I mean, I wasn't kidding when I said their best option is to settle. That is genuinely the truth. It is genuinely the truth. Settle, please. But for you, but not for me. I mean, I don't want you to settle, but you should, right? But you can shadow box. And if all you did was an hour of straw manning, that would be commentary. But you need to add enough. So on the rare occasions that that Denims does provide brief commentary or style or substance of the works, she spreads misinformation that is refuted later by the works themselves or by most cursory level of research. On rare occasions, when she actually shows the factual basis for her claims, her statements are refuted by the cited source itself. Such misinformation fails to serve copyright's goal of enriching public knowledge. So this is a point, but this is a weaker point. So this is why he made this his C point. It's not a bull. It's not bad, but it's not A or B. His A point is really strong. B point is very strong too. This one, it's got some power, but it's not. Let's see what his D point is. Finally, Denims will even do an empty chair reaction where she goes off camera for an extended period of time while letting the video play to keep her audience entertained. So this is the weakest one out of A, B, C, D because there's no specific citation. There's no specific legal citation that says empty chair reacts are illegal. Now there may be after this one, but there's no specific site. So legally it's the weakest. So literally you have your A tier argument, B tier, C tier, D tier. Isn't that cool how that works out? And Denims, Denims may even fail the D tier. Let's just say it that way. The poverty. I like this. Once again, good writing, entertaining writing. The poverty of Denims' commentary, coupled with her highly commercial use of the works that she specifically intended to serve as a substitute for the originals, fails to justify copying the TEI's works in their entirety. Rather, Denims' group viewing session is a quintessential example of copyright infringement, i.e. the unauthorized exploitation of TEI's works to get the attention and avoid the drudgery in working up something fresh. This lawsuit is to hold Denims accountable for her infringement and the H3 snark Marlets accountable for materially contributing to her infringement. This is a very strong intro, very engaging, lots of good words, clear to the point, tells you what you need to, not too long, very convincing, A+ intro. I like the intro. The intro's good. The intro's very, very good. So far, legally, I like the Denims intro. Let's get into the stuff. Now, we're going to probably skim some stuff here. Obviously, jurisdiction, it's under the Copyright Act. It's under federal court. So once again, no cameras in federal court in California. And the venue is obviously the Central Court in California. So TEI is a California corporation based in LA, which it produces on YouTube. Denims is an online streamer who releases content on Twitch and resides in Van Nuys. Shout out to Van Nuys, California. I've been there a time or two and not back in the last 15 years, but yeah, sure. The H3 snark mods are comprised of DOEs 1 through 10. Their true names and exact nations are not presently known. So they are going to become known. The mods are all going to become known. This is where they should be really, really scared. So also in the chat, someone says, isn't this doxing? This is a publicly available document, right? A publicly available court filing, right? So no, the answer is no. Okay. Let me go here. Doe1 is female, the founder of the Reddit and one of the snark mods. She used to go under the Reddit name Ozempic Dealer, while Doe1 subsequently deleted. Her last post was in February 25. Doe1 used the Discord handle Yogi Bearx and the screen name Paris Hilton. Doe2 is a female, resides in Canada, and head of the moderators. She is under the uname H3 Snark Mod Team 2, Roman P, and Right Salamander, and uses the name Doe number 2. And then she's got all these other names, such as Kitchen Mukbang Star. Interesting. Doe number 3 is another head mod, and he goes by the name Sarah Horn Jewitz, which has been publicly deleted after deleting Doe number 3 using a Reddit username Jewitz Sarah Horn, or Jewett Sarah Horn. Number 5 is on Discord as Roz Whalem. And number 5 is a male by the name of Tony. In Discord, he's from Pooh. And doe number 6 is H3 Snark Mod. No reception. And doe 7 through 8 are the remaining H3 mods. So they don't have the full information on those yet, but they will. TEI was founded in 2016 by Ethan and Hila Klein. The Kleins rose to prominence on YouTube for through channels H3 and Ethan and Hila. The Kleins created highly stylized reaction videos to other YouTube videos. The Kleins reaction videos are interspersed with relatively short segments of original video and long segments of commentary. So what they are doing is saying our commentary is legit and it's different than your commentary. So the Kleins in a inception level are using their own case law that they created on YouTube, using their own case law in a new lawsuit to create new case law. This is legal inception, which makes it fascinating to me. In 2016, the Kleins were sued for copyright infringement. So now they're citing their own case. Again, crazy. Kleins were sued for copyright infringement, defamation, misrepresentation under 17 USC 512 by Matt Hosendaya, aka the Bull Guy, Matt Haas. The copyright claim concerned a reaction uploaded to Ethan and Hila. The video entitled The Big, the Bold, the Beautiful was critical and humorous reaction to Matt's video, Bull Guys versus Parkour Girl. As the court explained, the Klein video opens with commentary and discussion between Ethan and Hila Klein, followed by segments of the Haas video, which then play, stop, and continue to comment and criticize. The Klein video, which is almost 14 minutes long, intersperses relatively short segments of the Haas video with long segments of commentary, ultimately using 3 minutes and 50 seconds of the 5 minute and 24 second long Haas video. The Klein video is harshly critical of the Haas video and it involves mockery of the performance and what the Kleins consider unrealistic dialogue and plotline. So there's a lot of fair use elements in there. In addition, defendant's commentary refers to the Haas video as quasi-pornographic and reminiscent of cringe tube genre, also known for cringeworthy sexual content. As critical as it is, the Klein video is roughly equivalent to the kind of commentary and criticism of a creative work that might occur in a film studies class. So they're saying clearly fair use because there's already case law on film studies class. The court granted summary judgment for the Kleins. So summary judgment, just so you guys understand, educational moment here, guys. Legal Mindset educating you. The procedure in a court generally goes in a civil case, motion to dismiss. That's whether or not there's a meritorious claim. So does the claim have merit? That's first. If it's vexatious, which is the big word Hassan used, which he doesn't understand, then it gets thrown out at motion to dismiss. Spoiler, this won't. So motion to dismiss, discovery, summary judgment, then trial, and then the final verdict and ruling, right? So summary judgment is before trial. And if you have a just open and shut case, you're just going to win. It's clear. Summary judgment will end it before trial. So if you are a defendant, it is very good to try to go for summary judgment and win because you never have to go to trial. You just win outright. And plaintiffs can go for summary judgment too if you have an open and shut case. And summary judgment isn't ruled on by the jury. It's ruled on by the judge. So I know there was a super chat earlier saying, is a judge or a jury going to rule on this? Well, they demand a jury trial. However, a judge could grant summary judgment for the Kleins. And this is a case where I think there is a good possibility the Kleins could get summary judgment. It could be so obvious that the Kleins get summary judgment. They don't even need a trial because it's such a killer case. So this is where I think they really got to sweat. The jury might not even save them. Just instant, boom, summary judgment. You're done. The TEI established the H3 podcast channel on YouTube, and TEI produced podcast episodes that were less structured reaction than the reaction videos the Kleins previously made. To ensure that any use of unlicensed copyright qualified as fair use, TI formulated and refined best practices, which included, whenever feasible, pre-screening the original work and outlining criticism and commentary before. 2, ensuring the commentary was directly related to the style and substance of the original work. 3, only broadcasting the portion of the original that is subject to critique. Very good. Not the entire thing. 4, pausing the original work frequently to provide critique. And 5, ensuring the duration of commentary was substantially longer than the portion of the original show immediately before. So I don't think you need to do all of those things, but that's what we would call belt and suspenders. Belt and suspenders in the legal world is when you do over and above to protect yourself. Your pants aren't going to fall down if you're properly wearing a belt and suspenders. The pants are going to stay up. You're never going to be caught with your pants down. But I think if you just do one of those things, that can often be enough. So for example, if you're just looking at a small part of the content, not the whole thing, that might be enough. And you're providing at least a baseline level of analysis. That probably is enough. That probably is enough. Denims, the alt-left's answer to Kelly and Denim LARPs as a revolutionary LARP. I love live action role play. And the fact they had to special that out, but LARPing is just so funny. LARPing is so funny. As a revolutionary from the comfort of her bedroom in California, I will say, okay, should I make a political comment? Should I say this? It's probably going to get me some salt here, but I do find a little bit of irony with if you've got $1 million house and you're talking about income inequality. But anyways, she is a prolific purveyor of misinformation and speaks with great confidence on topics where her knowledge leaves much to be desired. Denims repeatedly inserts herself into public controversies by employing poor judgment, knee-jerk contrarianism, and a consistent impulse to defend the indefensible. Includes copyright infringement, terrorism, and extremism. And once again, I don't want to get into the truth of this and whatever, like side comments aside, like, I don't care what she supports or whatever else. I'm focusing on the law. Denims is one of the most loyal and ardent defenders of Hassan Piker, aka Hassan Abi Hassan. So obviously, we can see who's Big Daddy. Big Daddy is Hassan. He is the, oh gosh, he is like the Jim Jones. He's the Jim Jones here. And it's like going after the cultists, not the cult leader, right? By the way, people brought up the thing, champagne socialist. Yes, it's always it's kind of funny. The champagne socialism is funny to me. It's like a laugh thing. It's a giggle thing. Much like Scientologists engage in fair game, I like the comparison to Scientology. Denims ruthlessly attacks with reckless abandon anyone who disagrees with her, Hassan. She parrots Hassan's style, rhetoric, and content strategy, regularly streaming React content with minimal transformative or commentary. As such, she has assumed a leading role in Hassan's waiting room, a collection of streamers who culturally follow Hassan and parasitically leech off his audience by streaming before him or after him. On November 17, 2023, in a now deleted video, Denims read Osama bin Laden's letter to America in its entirety on stream. She frequently expressed agreement and support for the letter, such as America deserved 9/11. I can't disavow facts, man. I can't disavow reality. That's not how works. That's not how that works, bro. Yeah, that's a hell of a look. That's a hell of a look. I'll just say that. Denims, reading for the letter. Why do they attack us in New York and Washington? If Ariel Sharon is a man of peace in the eyes of George Bush, then we are also a man of peace. America does not understand the language or manner of manners and principles. So we are addressing it using a language it understands. Denims responds, he is not wrong about that. The U.S. only understands violence. Bin Laden's criticisms of the United States are all correct. Interesting that I'm sure a judge and jury are going to love that. Despite Twitch's prohibition on terrorist propaganda, Twitch gave Denims a slap on the wrist by banning her for a day. By the way, while this stuff may not be all legally relevant, once again, judges and juries are humans and they have human emotions. And these things definitely lean on those switches, right? They definitely lean on that. And while they may be irrelevant, the judge may, or maybe not that relevant to the copyright part yet, they're very relevant to painting a character. They're very relevant to painting a character. It's not a good look because people are human reading this. This is not robots, right? On December 12th, 2022, Denims responded to the December 8th, 2020 video of June Nicole Lempine, aka Shoe on Head. Shoe-sided, which criticized Balenciaga's advertising campaign that depicted minors and highly sexualized BDSM, rather than acknowledge the widespread concern, Denims took the absurdly grotesque position of defending Balenciaga's ad campaign and attempting to paint Shoe on Head as a homophobe, despite Shoe on Head not mentioning homosexuality, whatever. So a lot of citations. Denim's involvement in the public controversy known as ReactGate provides great insight into her willful disregard for copyright. In early 2022, Hassan and Denims, along with several other Twitch streamers, received intense criticism for conducting group viewing sessions of third-party copyrighted content without permission. In these group viewing sessions, streamers like Hassan and Denims would watch entire copyrighted work with little to no commentary, sometimes even letting the video play while they were not present or while the streamer was sleeping. The controversy reached a fever pitch when these group viewing sessions included mainstream TV and this is where you FAFO. When you start messing with film, Hollywood has the lawyers to come for you. And this is where you go too far, right? And this is where you get in trouble when you start messing with people with money. And they mess with the clients who have money, which is where they messed up, right? The online content creator known as JXC released a video entitled Hassan Piker Jinx in the issue of reaction content. In the video, Jay drew a distinction between reaction videos that provide substantial critique and lazy reaction videos that are group viewing sessions. In particular, Jay focused on the group viewing sessions, including his poverty of commentary and penchant for doing an empty chair reaction, where he lets the video play while he's completely off screen. That's insane. His failure to credit the author of the original video and link. This is also crazy. Even to verbally, at least verbally say, go watch the video on this channel. At least verbally say that. Because, you should. You should verbally say that at a minimum. I don't always agree you have to post the link, because imagine if you watch a million clips, it always is hard to post all the links. I don't think you always have to post a link. However, you should verbally give a shout out. Hey, shout out, go watch them on this channel. At least say it verbally at minimum. I think it's a minimum. In a now deleted response video, Denims defended the unauthorized use of copyrighted content by asserting that viewers prefer watching streamers over original uploads, particularly when the material is curated. She claimed that established fair use standards are irrelevant to live streaming and need not be transformative for commentary and editing. Now, this is going to really piss off the judge, because to say that fair use is irrelevant, is completely irrelevant, and that live streaming and Twitch content is immune from fair use is going to come off as pure effing hubris. It is pure hubris to think that live streamers are immune from criticism, and that because you are a live streamer, the law suddenly doesn't apply to you. You are absolutely insane, and that point will never be accepted by the court. The court will never accept that fair use does not apply to streaming. That's insane. Now, what they might say is that if live streamers do XYZ, they can get out of it. They can, there's an exception here, but they're not going to say live streaming point blank is immune. That's crazy. That is insane. And the fact that she said that shows she's a complete, that statement is pure idiocy and has no basis in the law or really even rationality. It doesn't make any sense. Rather, Denims claim to be a streamer's personality alone can justify unauthorized rebroadcast of the copyright. So saying your personality, so Denims and her unique personality is so special. Denims is such a unicorn. She is such a unicorn, ladies and gentlemen, that the law doesn't apply to her. And I know that on Twitch, this word is banned, but I'm going to say it. I know some of her simps are going to agree with this. And I saw some of her simps are going to say, yes, queen, Denims is above all. She's Princess Butterfly of the universe, and she can do whatever she wants. But in the reality, not the simp verse, that is not real. Personality does not get you out of fair use. On February 6, 2025, Denims and JXE conducted a debate about the propriety of group viewing sessions that was moderated by the online content creator Chud Logic. The debate video, Chud Logic shout out. During the debate, Denims made several damning statements about her personal perception on the unauthorized use of copyright content. Most notably, she said early in the debate that she acknowledges she used third-party content as filler and siphons views away from the original. So she admits that she's infringing. I just want to be clear on my opinion on like filler content and stuff. Like, I think filler content, you shouldn't do it. I know I do it as a React streamer, so she's confessing to the crime. She's literally self-reporting. And I do it only with Vox videos or Vice videos and stuff like that, because I'm not like directly ripping from one content creator like a whole team. And most of those videos have 5 million views. I only get like 500 viewers. Like, I'm not even going to be taking I'm taking maybe 50 views from that video. It's a lot harder to feel, bad about that. So her argument is, I'm just a small creator, so they don't apply to me. No, that's not what's happening here. What's happening is they haven't found you, Denims, because to a large channel, your theft, you are a piss ant legally, financially to them. You are nothing to them because you're so small. They could sue you. They would win, but you're nothing to them. You are absolute nothing to them. You do not matter, Denims. So, but just because you don't matter doesn't mean what you did isn't illegal. Just because someone doesn't catch you speeding doesn't mean speeding isn't illegal. Just because you drive drunk and you don't get caught on a country back road doesn't mean it's suddenly legal. I don't know if you guys get, I don't know if she gets that. Shortly thereafter, Denims accepts her own bias and says, maybe I'm coping because as a reactor, when I have the content, oh yes, this is indeed coping. Later in the debate, Denims set forth her theory to justify a group viewing session of the third-party content. The Twitch streamers are curators that provide a communal experience of watching content with their audience who do not want to take time to find YouTube content of their own. That's lazy. That's lazy as hell. And it's not hard to find the content. You know, I'm sure if you click on a random part of the video, not be saying anything, sure, whatever. I might like walk away from the screen, but it's about like the communal thing. It's not about the actual show. So they're literally saying it's about the group theft and not about the actual substance. Oh boy, that's bad. And it's like, oh, it's the same reason you watch shows with your friends. You want to watch with other people. It's not, this is not like going to a Game of Thrones watch party. I think when it comes to streamers on Twitch, a lot of people are going to go watch streamers on Twitch for their React content as a curator. So they don't actually want to go through YouTube and watch a bunch of videos. Once again, as a substitute. And they probably will never will go through YouTube and click a bunch of videos. They're like going to Twitch because they like to have it as this streamer is curating fun content and want to watch it. This is once again Denims. This is all Denims is saying. All these are horrible arguments. These are horrible arguments that all go to her being a bad faith creator. This is all bad. I think that people who are watching content on Twitch, curated Twitch content on Twitch, aren't necessarily people that would be watching content on YouTube. So a lot of these arguments boil down to the fact that Twitch lets people get away with. And just because Twitch is a very unfair mistress that does enforce their rules unequally and does not enforce what should be enforced in terms of protections as rigorously as it should be, doesn't mean it's the right thing. It's like just because there's two cops, right? YouTube is the cop that paid attention and got top marks at the academy, right? So YouTube is the top cop. They're the one that catches all the criminals. Number B, Twitch is the fat, drunk, lazy cop who only has the position because his dad is the mayor and he needed a job. And he stays in his car watching Hassan Piker videos all day while huffing donuts, right? That's Twitch. That's YouTube, right? That's the comparison there, right? That doesn't mean the laws change because a cop is not good at enforcing the law. A lot of the time, the reason that they go and watch React streamers is because they don't want to have to do the effort of going and scrolling through YouTube and clicking on recommends. They're literally saying it's because they're lazy. The people who watch Twitch content are specifically there because they don't want to scroll through YouTube. Denims ultimately concedes that when a viewer watches content curated by a Twitch streamer, it serves as a substitute. Once again, that's it. That's the killer. There's no point of watching something a second time. You already watched it. Maybe like you're going to watch it with some other people or something, or it's been a long time, or you might rewatch the video. But once you watch the video in one place, it's unlikely you're going to watch it again, meaning it's a substitute. She says again, if you watch someone's content in someone else's stream, there's a low likelihood you're going to watch it separately. So once again, substitute is an element. Let's continue down here. Okay, rampant copyright infringement. Okay, so getting past all that good stuff. Despite their hatred towards the clients, they users of the H3 Snark Reddit have an insatiable appetite for their content. The Snark users, however, did not want TI to receive any views or advertising revenue for their consumption of TI's content. As a result, H3 Snark has become a locus of copyright infringement of TI content as detailed below. One method the H3 Snark minutes employed to consume TI content was to share links to TI content on YouTube, a website which provides unrestricted access to YouTube videos and public performance them, which constitutes copyright infringement. So they're using technology which enables them better to infringe. That doesn't look good either. YouTube has a particular appeal to the Snark Reddits and H3 Snark users because a video watched on YouTube does not result in a view or advertising revenue of the original on YouTube. H3 Snark mods conducted live chats during TEI's live broadcast. During live chats, the H3 Snark minutes would spam the chat with YouTube links of the broadcast. Once the live stream ended, they concealed the evidence of their infringement by deleting the logs, but they can get those logs. Below are true and correct screenshots of the mods spamming the live chat. So this right here is pretty damning. So you've got the screenshots, got the screenshots. Doe encourage, so that's one of the mods, encourage users to use YouTube as an alternative to watching TEI's video on the official channel by commenting on certain posts. The comments were then wiped. Due to Doe's efforts, the user was anointed as a mod. So obviously not good. We encourage folks to watch on YouTube so it doesn't play ads and contribute. So once again, going to substitution right there. They created a post to that effect right here. And they have tools, tips, and guides. And they hide their inducement by deleting the portion of members-only content from their guide. A true and correct screenshot regarding members-only content is below. So showing that they were even stealing members-only content, which is a paywall, right? TI issues takedown notices for infringing posts and comments on H3 Snark. TI began to fight back against copyright infringement on H3 Snark by issuing takedown notices, which went to 17 USC Section 512. TI was extremely surgical about which H3 Snark posts would be subject to DMCA takedowns, relying on the most pertinent fair use decisions. TI issued DMCA takedowns for only posts and comments on the entire episode, particularly paywalled content. Comments that provided YouTube link to the entire episodes and TI content, or posts that contain a clip of TI content with descriptive, non-critical title and comments that were locked by the H3 Snark mods, and there were no comments after several hours. August 1st, 2024, DMCA takedown. On August 1st, TCI issued a DMCA takedown for H3 Snark entitled H3 Live Show Beyond the Scenes. The post contained a complete version of TEI's video, which was members-only content. On August 2nd, 2024, Reddit honored this DMCA takedown. On August 30th, TI issued a DMCA takedown for the comment by Doe number 3. And that's also there. December 18th, TI issued a DMCA takedown for the H3 Snark Reddit entitled Ethan and Dan confirmed that posting to Snark will get you banned. The post solely comprised of a clip from the TI video Ethan debates anti-Semitic Sneeko fan. The post contained no comments because HCI mods locked the Reddit. So once again, this is all stuff they're trying to hide, right? More takedowns. So we'll just go past that because it's just listing more takedowns, more DMCA takedowns. So we can kind of skip that. So they issued a lot of takedowns. That's the spoiler there. And takedowns are a process. So the DMCA is a Digital Millennium Copyright Act. So that's a process by which you take down infringing video. So they had to do that a lot. That's the TLDR there. The H3 Snark mods efforts to issue fraudulent counter notifications. H3 Snark mods made a concerted effort to find fraudulent counter notifications to DMCA takedowns. So the counter notifications are when you can fight back. So Reddit informed that there would be a so-called counter notice issued against the August takedown. So they issued that one. And the counter notice failed because it failed to include their address and telephone number. That's a big one. Consent to jurisdiction, and a statement made under a penalty of perjury. So they didn't do a proper counter notice. So that's one big thing. That's one big thing, is that you have to, and pretty much dox yourself or give the information of your lawyer when you do a counter notification. So you can give your lawyer's information or dox yourself. So one thing people often do that are kind of trolly is they try to DMCA you to get your docs. It is also evident the first fraudulent counter notice was issued by the H3 Snark mods because, as we stated, we are writing to contest the removal of 2 posts from our subreddit under alleged copyright claims. We believe these reports may have been filed by fans rather than the legitimate copyright holder. So these are once again failing. So the counter notices are failing. The counter notice failed again because the law is wrong. So a lot of these counter notices are failing, and they also failed fair use. So these are once again failed attempts by H3 Snark when they were trying to repost information. So let's go down here. So now we have other conduct that involves concealing unlawful behavior. First, deleting posts after Ethan announced legal action. Now, this is a big problem, and the posts are obviously archived. There's going to be places on the internet to find them, and also Reddit themselves is going to have those documents. So, yeah, that's not going to work out very much. They also abuse the live chat feature on Reddit to promote harassment and defamatory statements, including promoting some of the egregious offenders into H3 mods. They use sock puppet accounts to conceal their identity. Once again, not necessarily illegal, but just shows deceptive behavior. And also last, they purposely lied about the takedowns to conceal copyright information and to obfuscate, meaning hide, big word. So for the Hassans out there who might not know how to properly use big words, obfuscate means hide, buddy. It means hide. Their intent to siphon views and ad revenue away from the TI. TI creates and registers the Nuke. By the fall of 2024, Ethan and Gila's concern reached a fever pitch over Hassan radicalizing his audience with propaganda from Ansar Allah, the Houthis, Hezbollah, and the Hamas. That's a hell of a lot of H's in there. There's only one H that's missing from that, and that's the Austrian painter. The clients were equally concerned with Twitter's refusal to enforce its community guidelines against Hassan and his so-called waiting room. Other Twitch streamers like Denims who parrot Hassan and parasitically leech off his audience by broadcasting immediately or after his streams. Hassan and his waiting room hijacked the necessary and important discussion of the Israeli-Palestinian conflict in the Gaza war. They employed rhetoric that painted Israelis as subhuman, blah, blah, blah. So once again, content, the fact that this is about the Gaza war doesn't matter. What is the content. Like, what did they do with the content? And that is the content nuke. What did they do with the content nuke? Well, the content nuke was obviously a video on Hassan. And let's see here. The deposit copy, the one they filed with the Copyright Office, was received on January 28th. The deposit copy varied slightly, so it doesn't have the conclusion or the sponsors. But otherwise, it's the same, other than to prevent the nuke being age restricted, they blurred out footage of the Houthis. So the Houthis were blurred. And there were minor visual edits. Ultimately, all the deposit copy was incorporated in the browser. So the deposit copy is more than the broadcast version, except for the sponsors in the conclusion, right? Okay, the nuke is we know what the nuke is, right? So we all know the nuke. It's about Hassan, right? So we're not going to go over what the nuke is. We know what the nuke is, right? There's a bunch of segments in it, right? And it's about Hassan, and it's kind of roasting Hassan and going over all that good stuff. So this whole is explaining all of what the nuke is. I don't need to explain the nuke to you. You guys can just go watch the nuke and see what the nuke is and see for yourself. And this is a lot of the value here. So I'm going to skip this part because it legally doesn't matter what the nuke is, but the nuke is a very long video. I have watched parts of it. I haven't watched all of it, but it's a very long video. It's a very long video. So he details all of it. And then he details the countdown episode. So he says, okay, here's what the countdown episode is, right? So they also made a live broadcast immediately before. So that's kind of like what I do with my videos. I do my live streams right before I do my fast facts, my premieres. So it dumps into it because that works better. So Ethan Klein is using the good tactic, the same tactic I use. So good move, Ethan. Good move. Not that you don't know about YouTube, because clearly Ethan knows better about YouTube than me. He's doing better than me. But I'm doing pretty good. I mean, 9,000 live viewers is pretty good. But Ethan's doing a little better. A little better. So TI made a big broadcast leading up to the nuke. After TI discovered Denims infringed on the Countdown episode, it registered the Countdown episode with the Copyright Office. So both were registered. So the H3 Snark promotes Denims as a substitute. So literally, the H3 Snark Reddit tells on Denims and increases the legal case. Hassan Snark mods knew there was a huge demand to watch the nuke through unauthorized channels and promote group viewing sessions of the nuke. So that's, once again, the group viewing sessions, real problem. Posting about that, a real problem. And here's detailing the posts and all the posts they made, inducing people. So now they're going to have the law of fair use and reaction videos. Okay, so we're getting into the law. Let's do this. Fair use is codified in Section 107 of the Copyright Act. The statute sets forth 4 non-exclusive factors. So guys, this is it. This is the beef. These are the factors. So pay attention. These are the factors. The purpose and character of the use, including whether such use is of commercial nature or is nonprofit and educational. So these are clearly commercial and they're making money. Now, being commercial doesn't necessarily make it illegal. Next, the nature of the work. What type of thing are they doing? Is it parody? Is it comedy? What is the type of the work? What is that doing? Right? Right? Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect and use upon the provincial market for and value of the copyrighted work. So the market. So if it is a substitute, that factor is going to be failed. Also, the amount. So the whole thing. So if the whole thing is used, that's not good. The first fair use factors relates to the problem of substitution, whether the new work supersedes or supplants the original. In this case, ladies and gentlemen, yes or no, is this intended to supplant the original? The answer is clearly, like without a shadow of a doubt to me, the answer is yes. This is meant clearly to replace the original. The central question is, does it add something new with further purpose and character? The mere fact that the secondary use has some purpose is not enough. It has to have a further purpose and meaning and a different character. a matter of degree, and the difference must be weighed against other considerations like commercialism. So you have to take the fact that they're making money on this into impact as to the amount of commentary. When you weigh those, how does it come out? And this doesn't look good for Little Miss Denims. While a use that has further purpose or different character is said to be transformative, transformativeness is a matter of degree. Indeed, an overbroad concept of transformative use, and one that includes any further purpose or a different character, would narrow the copyright owner's exclusive right to create derivative works. To preserve that right, the degree of transformation required to make transformative use an original must go beyond that required to qualify as a derivative. The first factor also relates to the justification for both use, both in the broad sense and narrow sense. A use that justified in the broad sense if it has a distinct purpose and that furthers the goal of the copyright, namely to promote the progress of science and arts without diminishing the incentive to create. A use is justified in the narrower sense when it is reasonably necessary to achieve the user's new purpose. Such justification is particularly relevant to assessing fair use. The wide dissemination of the secondary work would run the risk of substitution. So once again, the court is concerned about substitution. A critical book review illustrates how a secondary use must be justified. In the broad sense, the use of the original serves a different purpose than the book. Each quoted passage of the review likely serves a different purpose, an object of criticism, than does the book. Critically, this may not always be so. A court must consider each within the whole to see whether the copying is fair. Even book reviews are not entitled to presumption of fairness. So nothing is safe. Once again, copyright is a case-by-case analysis. Any lawyer that tells you they can 100% predict how a fair use case is going to come out is full of baloney, okay? Because nobody knows. It's always case-by-case. But you can usually say, which side did the scales tip on? Yeah. Let's continue. When the commentary has no critical bearing on the substance or style of the original, to claim fairness in borrowing from another's work diminishes, right? And other factors like commerciality loom large. So how many people watched? How much money did they make? That's the balancing. The balance is the fair use side, but okay, how were they profiting on this? And if there's a lot of profit, there's a lot of weight to fight back. And Denims did have a lot of viewers. That's a lot of money. A defendant copies more than is necessary to facilitate comment or criticism. The law is clear. To be considered transformative criticism, the aspects of the work that reproduce another's protected expression must be in service of commentary on that work. It is not enough for part of the work to have transformative purpose. When the use of the copyrighted work is not consistently transformative, and for when the clips are played without much interruption, if any, and used in excess of the benign purpose, that is a problem. The use of voiceovers and headlines and captions and wholesale copying sprinkled with written commentary fails to sufficiently transform. So just voiceovers aren't enough. Additionally, when copyrighted work is simply used to illustrate what a work already depicts, the infringer adds no purpose. The first fair use factor does not favor any user who wants to reach different buyers in different markets, consuming different products. So just because they're on Twitch instead of YouTube doesn't protect them. That is no protection. So being on Twitch versus YouTube or any other platform doesn't change anything. Commercialism examines the degree to which the new user exploits it for commercial gain, as opposed to incidental use as part of commercial enterprise. When it is motivated by profit. Further, if the defendant is not advertising a scholarly critique, but instead seeks to profit, at least in part, from the inherent entertainment value of the original, the use is commercial. Commercial means bad. Commercial means not allowed. Finally, commercialism exists when a secondary user makes unauthorized use of a copyrighted material to capture significant revenues, as opposed to a direct consequence of the copying the original work. In Hosendaya, the court found the first fair use factor favored fair use because Klein's video was quintessential criticism and comment on the Haas video. So once again, proving the Klein, this is the high IQ move that Ethan's doing. He's proving, because he won a copyright case, he's proving that he knows copyright. He's using his own case law. The Kleins were consistently transformative. So they're good beans when it comes to under the law. Second, the nature of the work. So this looks, is it creative? Is it creative? So the court found in the other Klein case that what the Kleins did was a creative work despite being published. The third factor said that the quantitative amount and qualitative value of the original work used in relation to the justification for the use. So how much are you using? When the amount used is substantial with relation to the infringing work, it is evidence to the value of the copyright work. Copying an entire work is against a finding of fair use. It militates, big word, against the finding of fair use. So meaning, if you copy an entire thing, it's not a good look. The new user only copies as much as necessary for his intended use. This factor will not weigh against the new user. That's in the Precedent case. In the Hosendaya case, the other Klein case, the Klein video copied a great deal of the Haas video, but that was necessary for comment and critique. The last is the undoubtedly most important factor, and that is whether the fair use is a substitutable purpose. Whether while the first fair use factor considers whether and to what extent an original work and the secondary use have a substitutable purpose, the fourth factor focuses on actual or potential market substitution. So was this substituting the original in the actual market? And the answer to that, the most important of copyright questions, not according to me legal mindset, according to the real law, it's Harper and Rowe, the 1985 massive copyright case. If you've taken copyright law, you know that case. Very important. What is it? Is it a substitute? The answer is yes, it is. They are in deep trouble. This is why they do not survive, or they get past a motion to dismiss and they get to discovery. I cannot see that not being a case. Denims group viewing sessions failed to make a fair use of the copyright of the Countdown episode. It is readily apparent that the primary and overriding purpose of Denims' use of the Countdown episode was to commercially exploit a group viewing session of the Countdown episode to serve as a substitute. This is evidenced by watching long sections without any commentary for several minutes. In separate instances, she provides empty chair reactions. So she's off screen for a long time. In total, of the group viewing session was 1 hour and 3 minutes. During the group viewing session, Denim provided approximately 4 minutes of commentary, 43 seconds of partial commentary, and 2 minutes of unrelated and unintelligible content. So in simple terms, it was uninterrupted for 88% of the time. I have not watched the Denims video, but that is absolutely cooked. The fact that there for only 10 minutes roughly, we're not even less than 10? Are we going for less than 10? Less than 10 minutes. 88%, she's cooked. I mean, I now move my percentage for Denims losing above 90% here. Denims is oof, that's bad. Denims also had a Countdown episode take up approximately 3/4 of the screen, while she occupies only approximately a quarter of the screen to de-emphasize her presence. Her objective was to provide a large, unobstructed view to her audience, with further emphasize her primary source was a substitute. Her use of the Countdown episode was clearly commercial. Not only did she receive paid subscriptions, donations, and advertising revenue, but she used the Countdown episode to advertise her group viewing session. So that's not good. She also added a statement on screen that was a countdown. She added a countdown timer and said, if you want to watch it, come and enjoy the watch party elsewhere by encouraging people. So all of these factors, all of these things are going against Denims. Let's continue here. As stated below, Denims' group viewing sessions of the Nuke exemplifies her belief that about the copyright that she experienced during ReactGate. Her group viewing session of the Nuke epitomizes her unfounded opinion that copyright infringement and fair use principles are inapplicable to live streaming. Her seriously deranged view, which is in no way based on the law, that live streamers are like Laffy Taffy, that they are immune from any part of copyright infringement. That is insane. They are not Laffy Taffy. They are not the juggernaut. It's not happening. Number two, her misguided notion that she is not obliged to transform a work with substantial editing and commentary. Her narcissism and misplaced sense of privilege that her personality is sufficient to justify highly commercial unauthorized exploitation. Yeah, that's the fact that she thinks that personality, that your magical personality of herself, not somebody else, her own magical personality is enough. No, darling. No, it is not. Her group viewing session is was the pinnacle of her career. Imagine if people at the pinnacle of their career are taken out. Crazy, right? At its peak, Denims' group viewing session on Nuke received approximately 45,800. This is exponentially more than she received in her entire career. It put her career in overdrive. It gave her huge peak viewers. Her concurrent viewers peaked up. So here's her stats. Her stats have gone up, right? It's readily apparent. So that's clear proof she profited. So she repeatedly says, we're relying on you to stay live so we don't give views. So it's a, not, so we're not doing stuff to the giving views to it. Yeah, I'm going to stream it. Since he confirmed it's coming out, we're going to stream it. So saying, come over here. So she puts out here, unfortunately, we're watching it, but we're not giving any views to that terrible video. We're acting as a substitute. And I appreciate you guys tuning in because I didn't want to watch that by myself. So acknowledging that she's doing it for substitution. There are probably a lot of people that came here to watch it because they wanted to see what someone who would disagree with it would say, but saying they came there to watch it instead of Ethan's side of video. Denims attempted to feign ignorance that H3 Snark is transparently and comedically false. Rather, it is clear that Denims and H3 Snark mods coordinated their efforts. Indeed, after ending their group viewing session, Denims' screen shows that she had the H3 Snark meta on her screen. Ooh! Denims began her group viewing session on the Nuke 1 minute after the Nuke was released to the public. So there was no time. There was no time for them to go and watch it on Ethan's channel and then come to Denims. It was the actual factual replacement. A lot of self-snitching here. On the 74 episodes, separate occasions, Denims' group viewing sessions consisted of watching the Nuke for 30 seconds with no more commentary whatsoever. These excerpts comprise 70 minutes of the Nuke, 70% of its runtime. 70%, guys. 70%. Insane. For the majority of her group viewing session, she speaks briefly after showing a long excerpt. The fact that the excerpts show the Nuke frequently eclipse her statements emphasize the primary purpose was a substitute. I just can't believe that the excerpt, so she only commented for 30% of the Nuke. She commented for 30% of the Nuke. The Nuke, like just playing it uninterrupted is 70%. Crazy. Crazy, crazy, crazy. During Denim's group viewing sessions, she admits she is not providing sufficient commentary because she does not want to pause. Well, what's the problem with pausing? If I sat here and explained what's wrong on half these things, we'd be here for 20 hours. What am I doing right now? You can stop and talk about it. That's okay. In fact, that's good. That's what you should do, is stop and talk about it. Stop and talk about it. It's not a problem. It's not a sin. But yeah. I've gone in to try to explain why he's correct on 1 in like every 10 incorrect takes, because I'm not trying to spend an entire week here. I don't even understand what to say, because this is wrong because this and this, another wrong take, another wrong one. Well, I just paused it for like 10 minutes. I feel bad pausing it again, because surely there'll be something better here. Denim's admission that she failed to address the majority of the points is self-evident. This failure emphasizes Denim's primary purpose was to host a group viewing session, and criticism was an afterthought. That's the main key here, is that the criticism is not the main point of her video. And he brings that up with several examples. And I'm going to skim these because there's just a lot of examples. So Denims fails to address the Hamas section. Denims fails to address the Twitch section, right? Denims even mocks the Nuke for making fair use of third-party clips, right? Denims does speak during her group viewing session. Most of her statements are brief in relation to the preceding section shown of the Nuke, but have no critical bearing, such as making utterances that are totally incoherent and unclear, or spending time speaking with her chat on topics completely unrelated to the Nuke. Well, guys, look, listen. I can't judge that. I talk to chat on unrelated topics all the time. Continuing on. Such as, let's see, Denim's frequently making superficial comments, such as referring to it as a high school project, a middle school project, calling Ethan so brave, saying she's going to die of cringe, saying Ethan is crashing out, saying they treat the audience as morons. Since Denim did not pre-screen the Nuke, she frequently expresses confusion about a particular excerpt. She did not pre-screen it and frequently makes comments that are later contradicted by the Nuke itself. Well, that's not okay. This is a weaker point. And this is why Ethan is putting it later. You do not have to. Let me make it clear. This is weaker. And once again, this is how I'm fair. It is a weaker point to say you have to pre-screen. You do not have to pre-screen. So this is not a winning argument. You do not have to pre-screen for you to have a legal reaction or whatever, commentary. You don't have to pre-screen. You can just do it raw. And I'm going to be honest with you guys in chat. On my channel, many times, we do it raw. We do watch it raw. And that is not a sin. That's indeed not a sin. Let's continue. Okay. In the section containing Hassan's apology of China's genocide, she claims that Ethan fails to point out how Hassan is wrong. Shortly after making these comments, they provide evidence that she was absent, which expresses the confusion. So, I mean, I think that stuff goes for more of she gets up and she's gone, and therefore she doesn't know, right? She doesn't know because she's gone, or she's not paying attention, or not providing good commentary. So we're going to go down after he gets through all the examples. And there were a lot of examples. Like there's like literally 10 pages of examples, right? Of which I'll read the conclusion here. Denim's conduct is so widespread. Several other members of Hassan's waiting room conducted a group viewing session immediately after. So the fact that all these creators did it, the fact that Frogan and Sean DeBlack and Casey Tron and Denims did it, the fact they all did it, makes it worse. That's a good example. So he finishes pretty strong. Let's continue. First claim of relief, direct copyright infringement against Denims. So here we go. Here's a legal beat. TEI is the copyright owner of the Countdown and the Nuke. It has a registered copyright. Denims accessed it, right? She played them. They had no license, authorization, or consent for her to exploit the Countdown episode or Nuke in any manner. Rather, their group viewing session constitute an unauthorized reproduction, public performance, and derivative work in violation of TI's rights in 17 USC. So, by the way, those random comments that people talk about Ethan Klein saying people can clip his content, that's not a license. That's not something that's going to hold up in court. I've watched it. No, it's not enough. So everyone who said watch it, like, oh, he said you could do whatever. No, he never said that. He never said that. Right? I've watched that. Due to Denims' acts of copyright infringement, they suffered damages in an amount to be determined at trial. Due to the act of copyright infringement, she obtained profits. They were done with actual and constructive knowledge, and they were willful, intentional, malicious, or taken with reckless disregard for their rights. Their second claim is against the mods. The mods facilitated. They knew this would infringe on copyright. They are responsible, and they materially contributed. Because of that, they suffered damages, and they had constructive knowledge. So they're asking for the following relief. So TEI, so that's Ethan Klein, wants to be awarded defendants. So that's both the mods and Denims and the H3 mods. They want to have all the profits plus the losses. So not only the money that Denims made, but also, more importantly, the money that Ethan lost, because Ethan lost more money than Denims made, because Ethan gets paid more for his views than Denims does, because he has sponsors and other things like that go into the equation. So she's getting DP'd, double punished, right? By her profits having to go to Ethan and Ethan's losses. That's a Denims DP, right? And H3 Mark DP, right? And that's what's attributable to the infringement. Now, TEI can also be awarded profits plus losses. Once again, I think the losses are the more substantial. Attributed to defendant's infringement of the Nuke, the exact sum to be proven at trial, or if elected, and here's why he had to register, statutory damages in the amount of $150,000. So, ladies and gentlemen of the chat, she is going to have to pay the losses of Ethan Klein plus her revenue plus at minimum, 150K. You got 150K on the top. That is spicy. And the judge could elect, by the way, the judge could elect to not employ statutory damages and can use the other method, right? But I'm saying if they choose statutory damage, 150K plus the damages, that's a lot. That's cooking.